Hi, my name is Andrew Kinney. I'm an attorney at Hoglund Law Offices. I do Social Security disability work. I've done it for about 2 decades. This is a video series. This is Social Security Disability 301. I have a number of different videos working our way through in a classroom type format how Social Security works, what are they looking for, how has it failed us, and it's pretty clear it has. With Social Security Disability 301, what I'm going to go through, my last video went through the overview of skills needed, and I'm focusing in particular on a hearing, or at least getting ready to eventually meet with a judge. One of the first skills that's needed if you represent yourself or the attorney that's helping you, or a non-attorney rep, is the ability to do research. It's one thing to understand your medical records, because with Social Security disability, they're looking into your medical records to see what limitations you have. But you need to understand is Social Security is interpreting your medical records their own way. They're going to decide how you're limited emotionally and physically. And the challenge there is that there can even be treating doctors that have opinions about your limitations. Social Security does ignore them, or at least we'll say it this way, they have to acknowledge them, but they do try to ignore them at times. Your research in medical records, let's say that now we're going to move to the role of an attorney in your Social Security case. The research into your medical records, there's a first round where you're getting familiar with, well, what's wrong, why can't you work, what's the rough rank order of the problems that my client has. But then there's a second level of research, and what you're looking for is the specific findings that support these diagnoses. If it's MS, there's an MRI. If it's low back pain, and perhaps again an MRI. If it's a memory problem, it should be a neuropsych test. Your research then goes to the third level. How supported are the limitations that you have? If someone has a memory problem that's too general, exactly what kind of memory? The neuropsych tests, using that example, lay out the different forms of memory, short, medium, and long term, and also other things that we might not think about, the ability to plan, use judgment, things like that. The idea here is that if you're going into a Social Security hearing, you need to know how your client is limited. And again, if you're helping yourself, you need to understand how you are limited. But there's more than that. You need to defend how you're limited. So if I am saying to a judge in a Social Security hearing, my client has certain problems, let's say low back problems, I need to point out where the MRI is. I also need to point out neurological examinations that support the sensory loss. Let's say there's radiculopathy or sciatica, the term I hear a lot. We need to be able to point out the medical exams and where they are in the medical record. So the research is to find out what's wrong, find out the support for what's wrong, then identify the weight of the evidence that supports what's wrong. Is there more evidence and support in my research of one limitation versus another? Is my client limited to sit-down work, or can my client do light work, as Social Security has defined in the regulations? Just so you know, that's in an appendix for the Dictionary of Occupational Titles. Social Security has used those exertional limits, essentially sedentary, light, and medium. Those are terms of art. But your research needs to be able to defend the limitations, whatever they are, physical or emotional, the ability to handle stress, the need to be off task up to 20% of a day, whatever the limitations are. Your research is not just to identify the problems, point them out, but it's also to defend them. Or if you turn it around, it's to take an offensive position, particularly in a hearing, and saying, here are 10 reasons that my client is limited this way, and I acknowledge some other evidence, but here are 10 reasons versus 2 reasons against. And so that's the balancing that you leave for the judge. Hopefully this presentation was helpful. If you have more questions about Social Security disability, just call the number at the bottom of our screen. I'll have a next discussion on analysis. Thank you. Hi, my name is Andrew Kinney. I do Social Security disability work. This is a classroom type setting, Social Security Disability 301. I'm an attorney. I've done this at Hoglund Law, and I've done this work about 20 years. This is a video series in a classroom type format. Last video I had talked about skills needed, and I'm focusing on a Social Security hearing. And we talked about research, analysis, medical vocational arguments, written and oral listening and questioning. I'm going through the second evaluation, the analysis. with analysis in Social Security hearings, we have an understanding that you have read the medical record and also understand how to support the weight of support the limitations that you have, and you can point out where in the medical record those limitations are supported. The next level of work in the analysis is to say, how are we going to take the problems that my client has in the rough rank order that they have them, and how are we going to anticipate the medical and vocational analysis. For instance, the medical analysis, there may or may not be a medical expert at the Social Security hearing. They are generally physical doctors, they can be psychologists. It's very rare, but it can also have two medical experts at hearings. Again, very rare, it happens occasionally. But you have to anticipate at a Social Security disability hearing, you have to anticipate what sort of testimony you'll have from an expert at a Social Security hearing. So anticipating that expert, you have to analyze where might they go, what is this, if you know the expert, what are their tendencies, and also how do the experts analyze the medical evidence, all right? So I'll give you some examples of medical. If someone has depression, I know some experts that review the record before the hearing. They focus a lot on the activities of their living forms from my clients, but they don't listen to the testimony at the hearing itself. With those kind of experts, I focus a lot on how their testimony at the hearing is reflected in the medical record. So I'm trying to get them to not just sit and repeat what was in their notes before the hearing. I'm actually, in my cross-examination of the medical expert in those instances, trying to draw the expert out, saying, well, I heard this discussion here and that is in the medical record here. I'm trying to make sure that the testimony is in sync with the treatment records, and then I'm trying to mention that the treatment records themselves support disability. So that's a sort of analysis. That's an example. If you know who the experts are and you also know the experts, then when you're preparing for a hearing, particularly for attorneys doing this work, when you're preparing for a hearing, you prepare certain ways. You have certain understanding of, well, I bet this expert will go one way or the other. Always assume with experts that they are going to testify against support. They will not support you. That's a better assumption. It's never helpful to assume they'll support you. That doesn't get you anywhere. The vocational analysis is an extension of the limitations you have. You have medical limitations. You're trying to figure out how these limitations translate to jobs that you used to do or other jobs. Now, there are some exceptions with the medical vocational guidelines. We look to past work, and then we look at skills from past work, and that would be subject to a different video here that I've had. But the overarching idea here with skills and analysis is, just like medical experts, there are always, or should always be, vocational experts at Social Security hearings. What are they doing? They are giving advice about, given a set of limitations and a hypothetical question from a judge, they are in turn saying these jobs would match those limitations, or of the jobs that match these limitations, 2/3 of them would allow that, or 1/2 would allow that. It is an estimation game. It is statistics appears to support it, but overall it is a very broad statistical analysis. It is not very specific. That's important, especially for federal courts, to understand this. With the analysis and the vocational analysis, when you're reviewing the record, you not only have the limitations, you also need to think in your head, what are the relevant limitations that affect the ability to perform work. So there is a rank order for the problems that your client has in a Social Security disability hearing. But if you think about it, only certain kinds of limitations are relevant for the job setting. If someone, for instance, has issues using their hands, a handling or fingering limitation due to, let's say, neuropathy, that has much more relevance than a feeling limitation. Let's say that someone has neuropathy, but the feeling element of it is rarely part of any jobs. So you need to have in your mind a funnel. Your client is telling you they have certain limitations, and then of those, certain are more important than others. I know that their day-to-day life is affected by some, but if you think about it, a person's day-to-day life may not be much impacted by a feeling problems, or let's say they can't taste things or smell things. The practical day-to-day life problems, opening jars, doing chores, things like that, usually are a pretty good analogy to work. If you have trouble stooping at all, a rare stooping limitation, 1 to 6% of the time, that is a limitation that starts having an effect on vocational testimony. If someone cannot stoop or just really can't stoop at all due to a low back problem, for example, that is one of the relevant limitations. So in your analysis, you need to collect all the limitations that your client has, and then you need to realize that different limitations are going to affect different jobs. Some limitations, no stooping, have a big impact on the job base, is the way they phrase it. It erodes that job base. Some limitations have little, if any, limitations. So it would be an error to notice that your client has difficulty sensing smells and to think that that would really have much impact on your case. Conversely, if certain smells cause asthma or trigger some breathing problems, well, at some level those breathing or medical problems impact them vocationally. If they cannot handle any perfume, if they can't handle any dust, it really does restrict the job base. Usually at hearings, the common phrase is no exposure to concentrated gases, odors, fumes. That is an end run around the real problem. It is rare that one would have concentrated exposure to things. Not even moderate exposure is what the state agencies use as nomenclature. So be careful with whatever hypotheticals that you hear at the hearing from the judge, that you're even going back to the state agency evaluation in the case of not being exposed to things in the air, fumes, odors, things like that. Make sure you're looking to not even moderate exposure. So what I'm giving you an example of is this vocational analysis. You can have a list of the different problems and how these limitations in turn affect function. Hopefully this discussion was helpful. The next video I'll talk about different forms of argument in a little more detail. Thank you for your time. If you have any questions for our offices about Social Security disability, please use the number at the bottom of our screen. Thank you. Hi, my name is Andrew Kinney, and I'm an attorney at Hoglund Law Offices. I do Social Security disability work. I've done it for 2 decades. This is one of a number of videos on Social Security disability. We put it in a classroom format. This is Social Security 301. The idea here is that I wanted to give videos in a certain order so I could do my best for many of those that I'll never be able to help to explain how Social Security works, how it doesn't work, and in this sort of system of Social Security disability, which by definition has to slot the problems you have, how do we make sure it's fair? And that's where attorneys come in. We talked about skills needed, in particular for hearings, research, analysis. Now I'm going to go into argument, written and oral argument in some more detail. Argument, people normally associate argument with just people going back and forth. A talk show where people are dissatisfied with each other. You see tension, you don't see much logic, you see a lot of emotion. That isn't very helpful. Emotion has little, if any, role in Social Security hearings. If there is an emotional response to logical argument, then your logical argument is on point, because we know there's a truth to people's problems. If that affects a decision maker or anyone else in an emotional way, it's not because you argue that someone should be approved because you like them. A logical argument, when it's really placed well, can affect ultimately someone's emotions because they just understand the truth for what it is. So expect with argument that you're focused on objective facts. Social Security has a reputation, for reasons I'm not quite sure, that you can just ask for benefits and you get them. Far from it. These aren't handed out, and the process is geared toward denial, and there's no question about that. With Social Security disability argument, what you have for written argument is you are taking someone, and in this case I'm anticipating a judge. I write to lower levels and generally I'm ignored. But written argument at the hearing level, what you're focusing on is that you have a certain audience. That audience is busy, just like any judge. But in Social Security realm, they handle many more cases than most judges do. They might handle 50 in a month. So as far as judging goes, state or federal judges don't compare to the level of volume that the Social Security administrative law judges will handle. And that may be controversial to say, but if it's true, it's true. With written arguments, you're getting a judge that is very limited on time. You need to understand, and perhaps my other videos will help, the procedural backdrop to anything you're asking a judge to do. Before a hearing, you might be writing a brief. The judge might be inviting you to explain in writing why your client should be approved. The procedure helps the judge know where this is. The judge knows that it's pending for a hearing. Maybe that there isn't a hearing scheduled and you're asking for an on-the-record argument. We don't need a hearing. But one way or the other, you need to lay out birth date, date last insured, application date, the onset date of disability, AOD, the date that your client says they can't work. You need to lay these procedural backdrop to your case so the judge can be comfortable in going right in, and then with that in mind, that structure in mind, going in and seeing the insides of your client's case. The written argument, the role of it may or may not be to actually win the case without a hearing, but it's certainly the goal is to persuade. Persuasion is a tricky business, and way attorneys are portrayed, generally they're portrayed as modifying facts. Well, actually the reality is far from it. With written argument, you need to give the procedural backdrop in whatever a two-page letter is, a brief to the judge, hence the name, brief. Then you need to give facts. An MRI, what did the MRI, when was the MRI, what did it find? On January 1st, 2014, my client underwent thoracic MRI. The MRI revealed balding discs at T3 to T4, and effacement of the spinal cord, T4 to 5. That is fact. That is objective scientific fact. A radiologist would have interpreted that from an MRI in this example. Your written argument should lay out not just those objective findings, but also give the story of the client, the medical narrative. Here are the accidents, if it was a car accident that led to a problem, or here are the series of surgeries. You need to not only identify the diagnoses that are relevant in a rough rank order, try between 5 and 7 problems at most, if you can. High blood pressure is only relevant, for instance, if you have kidney issues and other issues, or migraines. Hypertension in and of itself, it can even be symptom-free. It causes no limitation. So those are examples of choosing wisely in your written argument which diagnosis you mention. With the written argument, you mention the backdrop, procedural backdrop, the diagnoses, then you go into the facts. With the facts, you are citing in the record with references to the page. Here's an MRI on this date. Here's the surgery on this date. What was the surgery? Here's the recovery or lack of recovery, because that's a natural question. There is logic to this in a timeline. Lay out facts in a written brief. Don't argue till you're done laying out facts. Then in a new paragraph, my client should be approved of Social Security disability benefits because they are limited to less than sedentary work. Whatever your theory of the case is, do that in a new paragraph. There's where your argument comes in. You can then draw from the facts and say, based on this MRI and based on these findings here, they meet a listing. Or whatever your argument is, the actual persuasion part, put it in a different paragraph, get to the point. Your theory of the case draws on facts, and when a judge, or anyone for that matter, but when a judge is looking at the procedural backdrop and the facts, if that is a given, because they are what they are, and also mention facts that might be work against you, and you can weigh that in the argument. Make the argument short, tight, to the point, know your audience, know that you aren't getting to emotion, you're getting to why the law should approve your client, offer alternatives, perhaps a later date of onset, and you're done. So the focus of the written argument on the front end of the hearing is that. After a hearing, your written argument is likely going to be shorter. It'll be focused on 1 or 2 particular issues. I'm getting out of breath here. After a hearing, the written argument may start with a procedural backdrop. This person had a hearing with you last week. In the hearing, the vocational expert discussed, and you get into that. In reviewing what the expert discussed, I found an error in that, and then you lay that out. The idea is that the written argument after hearing hopefully is pinpointing a pivot point in the decision. If a judge's decision might pivot on a certain form of testimony from an expert or certain kind of evidence, you might be offering more evidence, you might be making an argument, but focus on what helps the fulcrum of the case in your post-hearing written argument. In my next video, I'm going to talk about oral argument. Hopefully this is helpful. If you have any other questions about Social Security disability before I run totally out of breath, just call the number at the bottom of our screen. Thank you. Hi, my name is Andrew Kinney, and I'm an attorney at Hoglund Law Offices. I've been doing this work about 20 years. This is discussion about Social Security disability. It's in a classroom format. This is Social Security Disability 301. Unfortunately, this is a class without credit. Hopefully I don't bore you. You're allowed to chew gum. Go ahead. This is Canada. It's not related to anything. We talked about skills in the recent videos: research, analysis, and argument. Right now I'm going to talk about a particular kind of argument, oral argument. Oral argument is unique. We all know that when we interact with people, that when we're actually physically next to them and interact with them, it's different than if we're texting them or emailing them or watching something like this, a tape. I would like to be able to talk with a lot of people in person as much as I can, but this is better than nothing, this video format. I hope it helps. In hearings, the skills that you need and the skills that an attorney should hope that you would want an attorney to have are ability to handle research, analysis, and argument. Written argument I discussed in just a prior video. Oral argument. Oral argument happens right before the hearing and during the hearing. Right before the hearing happens when some judges, right before a hearing off the record, would like to candidly or directly tell you what their thoughts are in the case, or if there's some confusion that can be clarified about procedure, you can deal with it right before the hearing. It's common that in a Social Security hearing that any discussions that you had with the judge off the record, you just say we discussed off the record a later date of disability or some particular issue with records, things like that. The oral argument, the point of oral argument before a hearing, with a Social Security hearing, is that you're trying to identify something that would be distracting and getting it off the table. If you are agreeing with your client agrees that you're not going to ask for disability until this past year, in the last 6 months, that helps clarify issues for a hearing. I don't want distractions. The hearing might be 45 minutes to an hour, and in that Social Security hearing that someone may have waited 2 years for, the goal is to use that time wisely. If there are distractions, if there are things that take the judge's attention away from the main point, that doesn't help your client. So those pre-hearing discussions and the goal of oral argument, and this may sound odd as argument, but oral argument can be that there's not an issue, or we are not claiming disability before a certain date or before a certain age. Age 50, 55, or age 60 are relevant medical vocational guideline ages. Your goal of oral argument is to try to, again, in pre-hearing discussion, take things off the table, put things on the table, and help focus the judge on where you're coming from, instead of having this dance of guessing who's thinking what at the hearing, which happens, and that's unfortunate. Oral argument at the hearing can take the form of a opening statement. It also takes the form of a closing statement. We traditionally consider argument coming from the attorney. So an opening argument isn't going to testify for your client. An opening argument, instead, the goal is just to get to it's a mini form of what the written brief will do. It gives some procedural backdrop, but it'll acknowledge, and you can know that the judge is aware of that by the time you're in the hearing. But then it'll go right to some objective evidence. Your theory of the case is what the judge wants to hear from you within like a minute or two. And with this oral argument, you're laying out why your case should win and alternative dates. Hopefully, though, a certain date if you have to amend onset dates. Fudging makes it hard to focus, especially if you're not sure how the case will resolve. You can acknowledge the judge will make a decision, but be respectful. Say, please consider this. I would have you please look at this. Ultimately here, if you heard this in a moment ago, oral argument on the front end, you're not going to testify for your client. The most I'll do, and I'll give you an example of substance addiction, that can be distracting for a mental illness case. It's definitely relevant. So I would say I discuss with my client in my opening oral argument, I discuss with my client the importance of being upfront about all chemical dependency use. The record shows this and this on these pages. My client can tell you about whether or not he has sobriety or is clean. I leave it at that. That makes sure that I'm not trying to hide the issue, and in fact, it in a way pushes it toward the end of the table, and then it might make it an issue or a non-issue. But the goal of oral argument, again, is to clarify and introduce. The closing argument will be a response to your theory of the case as it's tested through the hearing, through your questions of your client, through the judge's questions of your client, and through the experts' testimony and through your cross-examination. The closing argument would say, well, with all due respect, Your Honor, and you're identifying tension points in the case that can turn your case, that fulcrum of the case. Your Honor, please consider this evidence over that evidence, and although with all due respect, the medical expert thought this, I ask questions because I think it's reasonable that the MRI shows that they have chronic pain, or the chronic fatigue syndrome is diagnosed adequately, as the medical expert didn't. They're sitting right there, these experts. Your closing argument can address what people just told you. What you're trying to do is clarify yet again. But here you're trying to clarify depending on what happens at the hearing, because we have no idea what experts say before the hearing until we get in the hearing. That's why federal courts traditionally have no concept of the pressures of litigation that Social Security representation has, because most, if not all, civil litigation allows depositions. Please make a note of that, especially if you're a law clerk. The oral argument of the closing argument and opening argument is traditionally where people think of oral argument, but there's more. In my practice, I've realized that my questions for my client and my cross-examination questions have an impact on the case as well. They should. I'm not going to ask my client whether he likes the color blue. I'm going to ask my client things, if the judge started with questions, that maybe are unclear. If fatigue is your theory of the case while your client cannot work a full-time schedule, I need to ask more about fatigue. How much fatigue is it? Is it fatigue like when you're tired and don't get enough sleep? Do you have any descriptions of how bad the fatigue is, like a truck hit you? If you know that your client can describe fatigue better, I'm using my questions for my client in a way of oral argument. It's just my oral argument comes through my client. I'm helping my client mention relevant facts that in a scheme may sway, or in a sort of a seesaw way, tilt the case to have the judge understand the credibility piece. My oral argument isn't just what I say in the opening or closing. My oral argument is what I ask my clients. And also, and again, credibility can only be impacted by my client. If experts get into credibility, or experts get into uncertainties, my questions for the experts may not change their mind, but the goal is I have argument, I'm saying argument, in the form of questions that the judge may logically understand why I'm asking the questions. If during your cross-examination of medical experts, vocational experts at your Social Security hearing don't make sense to a judge, then you need to pull back and think why. The goal of your questions for experts at hearings isn't, again, to trap them like TV would popularly think. The idea is to bring reasonable arguments, logical arguments why your client can't work, or how we interpret a certain form of evidence or a certain kind of limitation in a certain way. Unreasonable answers from experts, you're trying to draw that out and stop. And then the judge will understand why you ask your questions. Your form of oral argument in terms of how you cross-examine these experts plays into your closing. So these are the ideas and the very brief litigation that we have, 1 hour intervals in 2 years. These are how we get a judge to know your client, and these form of arguments, thinking of argument more broadly, help focus, clarify, and help identify the problems, identify distractions, try to lead the judge, who ultimately has a decision to side with you or the other side, the government. And you need to have credibility, not just your client. Don't make arguments that aren't supported. Do your research. Analyze relevant medical problems and vocational limitations. Do your homework. When you're at the hearing, you want the judge to instinctively want to ask you, have you seen this, have you seen that in the record? If the judge is looking toward you and trusts that you'll have some good answer to those questions, that is big, because what you say carries some weight, as opposed to merely relying on the medical or job expert. Okay, thank you. Hopefully this discussion here was helpful in terms of argument. I'll do, if you have any questions for us, you can call the number at the bottom of our screen. I'm going to go into the last 2 skill sets, the last 4 and 5, in a moment. Thank you. Hi, my name is Andrew Kinney. I'm an attorney at Hoglund Law Offices. I do Social Security disability work for a living, and I've done it for 2 decades. This is a video and a series of videos ultimately on Social Security disability. It's in the classroom format. We're not in class. You can come and go as you wish. There's no test. What I wanted to do is discuss in about as blunt a way as possible the whole Social Security process, good and bad, ugly, beautiful, I guess, to use contrast, but to look through what really is going on, particularly at a Social Security hearing. So as far as skill sets go, we talked about, and I have prior videos on research, analysis, argument. Now I'm going to go into listening, which seems like a very generic skill. Social Security disability hearings are stressful. Your client comes to the hearing, you're their attorney, you need to be objective as the attorney. And clients that listen to this, your attorney needs to be objective. You don't want a friend, if at all possible, or a family member, although it's allowed. You need someone that can objectively step back and with all the things going on in a hearing, from opening arguments, questions for you, the client, and then expert testimony and cross-examination of that testimony, and then ultimately a closing argument, perhaps written argument afterward. Listening. If you are emotionally involved in a Social Security hearing, it makes it tough to listen as the representative, as the attorney helping a Social Security client. Why is listening important? Well, we would understand that the client answering questions from the judge about what's wrong with them, it's good for them to listen, but you need to listen to not only things you hear, but things you see. So you need to pay attention to cues. What cues? Well, if you go in before a hearing with a judge that's okay with that, and the cue is that there's no case, well, that should prompt you to do something different than just ignore that cue and proceed with the hearing as if you didn't hear it. The cues or listening skills before the hearing are relevant. Now we're in a hearing, and let's say a judge is asking a lot of questions for your client about chemical dependency. Well, you need to listen to the questions, not only what your client says, but the questions the judge is asking and how many they're asking. And if you know the judge well, you're trying to get a sense of how much weight they're putting on this particular impediment. Okay, so if it is chemical dependency in a Social Security hearing and you're listening to a lot of questions about legal history of chemical dependency and arrests, and which by the way come out and I don't always see them in the record, but if I'm if I'm listening to these things, that's a hint, or that's a sledgehammer, let's just say. The judge is hung up on chemical dependency. Chemical dependency, for instance in the case of mental illness, can obliterate the weight given to the actual signs of depression or anxiety. Okay, so the listening skills come down to this. If you are listening to the judge ask questions, or you're listening to the medical expert answer questions about chemical dependency, using this as an example of listening skills, well then perhaps one instinct is to try to hope that they don't ask any more, but that isn't very helpful in the 1 hour you have. Again, we have no benefit of depositions before Social Security hearings. We are totally blindsided by evidence, by testimony that experts have on evidence. There's absolutely nothing we can do other than wait to hear what they think, and then we have 10 minutes to ask questions. Again, federal courts, pay attention. This is not traditional litigation, but it is no less litigation. There are no rules of evidence, but the spirit of the rules of evidence absolutely applies, okay? And it isn't always in our favor. With listening skills, if you are noticing that chemical dependency in this example is coming out over and over, what is your cue? Well, when you listen carefully, you realize that you have not clarified whether the client is believable. Are they really clean and sober? So, interestingly, we call it adverse witnesses, but when I have a judge ask my client a lot of questions about chemical dependency, I'm going to go in. And I may even ask more difficult questions of the client, but I would already tell the client I might have to. Why? Well, if I'm not convinced that a judge is convinced of something, or I'm not convinced of something, I don't think a judge will be. How more difficult are questions when they're more detailed? I think more detailed questions are harder. So when you're listening and understanding these cues, your attorney should ask you more difficult questions. Well, I'm looking on this exhibit and it looks like you're shopping for pain meds. Is that true? When you ask your client before hearings detail about the record, which you should, sometimes things come to light that are interesting. Well, that one ER doctor thought I was using too many pain meds, and that got into my medical record. My primary care doctor noticed that, picked up on it, was really worried about it, talked to me about it, and kept bringing it up. I finally, and this is a client responding before the hearing, I finally went to my doctor, or I changed doctors, and I said, I have not abused pain meds. And then look, you might find as an attorney that there was some evidence 6 months later that Another doctor said, I reviewed this and there is no issue with doctor shopping or abuse of pain medications. You need to investigate and research good and bad elements of your case, your Social Security claim, with the idea that you're listening to see if someone else didn't, quite bluntly, okay? So if your research is better, sometimes research brings up bad things and there's nowhere to go. Well then, if your client agrees, well then you admit that. Maybe there isn't a case, but if your research and analysis is deep enough and your argument is ready and then you're listening, that is what happens at hearings. Listen to what your client says before the hearing, listen to what your client's saying to what the judge is asking. You may ask different questions when it's your turn, but when you ask your client questions and you're listening, then you're not asking the same questions the judge did. So I'll be adamant about this. You have judge's attention span in writing. We talked about that in a previous video. Now we have your judge's attention span, maybe the third hearing that day. Okay, pay attention. This is litigation, and this is the third full trial in essence in an hour compressed format. If you don't have the judge's attention span and the judge isn't listening to you, then you essentially may have considered yourself lost. There's no point in being there. You need to keep the attention by being clear, to the point, getting from A to B. The judge may have a sense that they want to be efficient at hearings. Even more so, get to the point. When you're asking difficult questions of your client, having listened to the issues, and you ask a more difficult question, that gets the judge's attention. And you know what? That may have taken that much to convince you that your client was really clean and sober with that discussion and the example I gave you. Well, go deeper with your client. So listen to what happens at a hearing. Don't have preset questions. Have a sense of what your questions will be for experts, all right, as an attorney. But you need to listen. You may need to adjust. And you need to be, well, you need to know that some issues that you think are important may not actually be important to the judge. And some issues that need to be important for the judge aren't. You're trying to set a different agenda for what are the real fundamental issues. There may be 2 or 3 at a hearing, and it may be not the ones you anticipated, but make sure you're noting that these could be, okay? So anyway, that's the discussion of listening skills, okay? So listen carefully during Social Security hearings. Hopefully it was helpful. If you have any questions, go to the bottom of the screen, you can call us. Thank you.